Our next witness is Mr. Abed Ayoub. Mr. Ayoub hails from Dearborn, Michigan, and is a graduate of the University of Michigan and the University of Detroit Mercy School of Law. He currently serves as the National Executive Director of the American Arab Anti-Discrimination Committee, an Arab American civil rights organization committed to defending the civil rights and civil liberties of all Americans, including advancing due process and equal protection. Throughout his career, he has worked to address issues impacting Arab and Muslim Americans in the United States, including matters related to discrimination, surveillance, profiling, and most relevant to this hearing, watch listing and screening. Under his leadership, the ADC Legal Department successfully assisted and provided pro bono support to thousands of impacted community members across the country. You are now recognized for your opening remarks.
Thank you. Thank you, Chairman Paul and Ranking Member Peters, for the opportunity to testify. My name is Abed Ayoub, National Executive Director of ADC. We were founded over 45 years ago by former Senator James Abarizik. Throughout that time, we have worked and assisted countless members of our community who have been directly impacted by government watch list process. And let me start off by saying something that may surprise some people, but I have sympathy and I feel really for MAGA supporters, for Republicans, and for anybody that's going through and experiencing the fallout of the watch list issues. That includes missed flights, repeat screening, frozen bank accounts, job consequences, and much more without notice or a fair way to challenge it. I don't need to share their politics to understand that rights and liberties aren't conditional on agreement. What they are experiencing today mirrors what Arab and Muslim families have endured for decades. A secret designation that follows you from airport to employer and sometimes to consulate, with no clear explanation and no reliable fix. That is not a problem. That is not a partisan problem. It's a due process problem. When the government can quietly tag one group, it can quietly tag any group. Left, right, neither, just depending on who holds power. The answer is the same for all of us. On the watch list, or at minimum, implement safeguards that protect our liberties and rights. Quiet Skies was a total disaster. ADC welcomes the decision by the Secretary of Homeland Security to shut it down. Retiring a program that surveilled ordinary travelers without evidence of wrongdoing is a meaningful step towards fairness, but Quiet Skies captures only part of the story. It is a window into faulty surveillance architecture, secret lists, vague criteria, and downstream sharing that harm people who have done nothing wrong. For decades, the watch list system has too often been a shortcut for suspicion aimed at my community members, not because of what we've done, but because of who we are and what we believe. People get flagged after visiting family overseas, donating to lawful charities, attending a protest, or simply for praying. That's not security, that's punishment for religion and politics. More than 98% of the names on the FBI's 2019 screening data set were Arab or Muslim. Placement on these lists does not require an arrest, charge, or conviction. Instead, it is based on vague suspicion, often tied to religious practice or, again, protected political speech. And again, let me be clear. If a tool can quietly target my community members today, it can target any community tomorrow. Journalists, activists, immigrants, gun owners, union organizers, pro-life, or pro-choice advocates. Once a secret label replaces proof, the only limit is who's in power. If you won't end the watch list, then at least cage it with real notice, evidence, hearings, and strict limits so no American's faith or viewpoint becomes a reason to be treated like a suspect. Placement on the watch list has a direct and dire impact that reaches beyond the airport. These harms underscore why there must be reform to allow for the redress removal from the list. The tracking of screenings and assurances of appropriate oversight, because the human and policy costs are real. The task is larger than ending one program. We got to take immediate steps to implement due process measures to afford those on the list an opportunity to be removed. Many experts and opinions, many of them here today, have provided a clear roadmap to fixing these immediate issues, such as requiring TSA and CBP to systemically track all screenings and outcomes so we can see where the system fails and who's being hit the hardest. Second, direct the National Terrorist Screening Center to report regularly to Congress on nominations, removals, error dates, the recall of bad data, and with safeguards to protect privacy while exposing a pattern of bias. Third, pair transparency with teeth. Have mandatory timelines, independent review that can order a delisting. The most urgent fix is transparency and due process. If the government is going to restrict your liberties, you have the right to know why. DHS's redress inquiry program, TRIP, provides little information to travelers about why they are flagged or whether corrections are applied across the system. Without systemic tracking, bias can go unchecked and travelers have no meaningful way to collect errors. Today, individuals on the watch list often receive no notice, no explanation, and no meaningful way off the list. There is room for bipartisanship on this issue, and I'm confident of that. I'll meet anyone halfway on this. Left, right, it doesn't matter, because the watch list isn't about who you voted for. It's about whether the government has to prove its case when it takes away your rights and limits your life. Mr. Chairman and members of the committee, eliminating quiet skies was necessary, but it's not sufficient. We need to restore transparency, accountability, and due process to protect millions of travelers and Americans. We stand by and ready to assist in that effort. Thank you.
Senator Peters.
Mr. Ayoub, one of the issues that I've heard again and again from people in the community and others is just how broken the redress process is for people who believe that they're unjustly or mistakenly caught up in the watch listing system. Mr. Crowell, I understand your wife, my understanding is not on Quiet Skies. She was put on the watch listing, the terrorist watch list program. So the redress process is really important. We still have that program in place. We need to have reforms, which was part of the work I've been doing and the legislation that I had that we did pass out a committee to deal with redress. But given your experience working with individuals who believe that they're on the terrorist watch list, what recommendations specifically do you have for this committee? What should we be doing right now so it doesn't happen to Mr. Crowler's wife in the future? It doesn't happen to the folks that you hear from regularly and I hear from regularly back in Michigan.
Thank you for that. Look, the redress process in the DHS TRIP program is flawed. It doesn't always work. It doesn't give you the reason why you were put on the list, and it doesn't give you a final decision. You fill out your information online, and you get a letter back saying some vague language like, we've received it. We can neither confirm nor deny that you're on a list. And it's not always effective. So we need to work to find ways to expand that due process, expand the option of being removed from the list, look at what existing programs are there we could take advantage of, which could review individuals coming in. You want to be proactive. If somebody's on the list, again, set up a proactive way for them to reach out and be removed. We have, my colleague at the end, who's a U.S. Air Marshal, who has far more access to being removed, still took him, a couple years to be removed. So imagine a regular individual going through the same thing. It's going to take much longer. But what we've learned through our practice is when we can identify that one piece of information or that one agent that placed that piece of information in there and then have a conversation with them, interview the client, and once that piece of information is removed, then the issue's gone. But it's going to be impossible to do that for 2 million people. There's just not enough agents and resources to go around. So finding a streamlined way, a streamlined due process measure, maybe building on DHS TRIP, that should be first and foremost, and dwindling down the list, and then also possibly maybe going through the list to at least purge the names of folks that have died, or children that are like 4 or 5 years old, right? Remove those names so you're working with a cleaner set of data to begin with.
Right. Well, I've certainly heard a lot from community members about the negative experiences, as you mentioned here, with the screening system. But just like today's testimony, which is powerful, I appreciate the testimony, these are anecdotal accounts, and we could come up with an awful lot of anecdotal accounts. But one of the recommendations in my report, and a big part of my bill, was requiring better and more complete data from CBP and TSA on all their screening practices, because there's like 20 plus programs. We're talking about one that's gone away. We still got a whole lot more of these things that are out there that need to be addressed. This is a big, big issue. So my question for you is, what do you think having better data, exactly what's happening to understand whether these processes are effective and whether there's bias, intentional or not, political, whatever it may be, we need data. What's your sense of that?
Absolutely. I think there should be data. We should be able to look at that list and determine why this person was added. Then at the end of the review, you'll find out, okay, were these, this group of people, do we have this many individuals added because they're Trump supporters or because they're Democratic Party supporters, right? We need to be able to read that. We need to be able to know why they're on there, who they are, what trends, and to determine what mistakes are being made. Because again, it can go just depending of what administration is in office, who's gonna be targeted. And our community for past quarter century, for past 3 decades or so, we're thankful enough to be targeted by all administrations. So we can tell you the experiences through Republican and Democrat administrations. But the reality is there are trends, there is bias, there are folks on that list that need to be removed. Expanding that option, expanding the way to do that, and having those data points, having that data set will also help develop policies and strategies moving forward to enhance and make the security process and the screening process better.
I'd just like to follow up, because this could happen in all administrations, both parties, whatever. This is a problem. We've got to make sure there's full transparency, there's oversight, regardless of who's in office. And most of the oversight in these systems currently is handled by internal DHS offices. The Office of Civil Rights and Civil Liberties, Privacy and Civil Liberties Oversight Board, as well as Inspector Generals who oversee this. However, unfortunately, this administration has basically gutted all of the oversight. So we don't have the oversight anymore. Can you describe the consequences of eliminating internal oversight will have on American civil rights and civil liberties with regard to screening and watch listing? So all of the issues that are being raised by everybody here today, we have to make sure that we're guarding against that. What are your thoughts?
Look, oversight is very important. The issue was bad with a functional CRCL office at DHS, and you can imagine it's be a lot worse with no oversight. So having that office, having some sort of mechanism there is important.